So this is Washington Arbitration Week. This is our fourth panel of the day, and I really want to. I mean, looking at the numbers next year, we're going to do a Saturday session. No, I'm kidding. But my team would actually kill me. I have been reprimanded by my former senior ICSID colleague who is moderating here, and he said, "No, you have to be quick because we're late." And I have also been reprimanded by my team, so I'll try to be quick. Just a couple of announcements. First of all, I'm Jose Antonio Rivas. Some of you might know me. Sorry for the bore, but for those of you that don't know me, together with Ian Laird, we co-founded Washington Arbitration Week 6 years ago. We have panelists that at the time were only able to appear online, and now they're in person, which is wonderful, including Viva, who is now here, and I meet her the first time in person. And we very quickly, Washington Arbitration Week has a sister event, which is the World Arbitration Update. It happens in May every year. It has had 5 editions, and it happens also during a week or more than a week, but consecutively in 5 or 4 continents. And we've been in Beijing, in Mexico City. We have been in Doha, Colombia, Singapore, Warsaw, etc. I mean, I can really refer you to the various 4 continents, and its mission is to update on international arbitration, both investor state and commercial, as well as public international law topics. And its second mission is to decentralize international arbitration. And by that, we mean that, as you know, in arbitration not only happens in Washington, D.C., or New York, or London, or Paris, but which are the main centers of arbitration, but it happens in pretty much all the continents, and they're marvelous arbitration practitioners, counsel, arbitrators in every corner of the world. So we're trying to bring those incredible counsel, arbitrators, practitioners, damages experts to the floor as well. Having said that, this is a topic that has been going on despite my own ignorance for many decades. In space law / international arbitration does exist, and as part of the Washington Arbitrations Week DNA, this is not a conference that people need to pay for to attend. It's cost-free, and people in any continent, in any place of the world can see you and can attend free of cost. In line with that, we really try to go out of the known arbitration community. Of course, we have incredible arbitrators and counsel who go to other forums and fora, but we also have individuals who have never been in this setting. We have individuals who have substance. Some of them have done PhD thesis or written about the topics, and we try to find them. And I'm very proud to say that in this panel, we have experts on space law, which are right here in Washington, D.C., that we hadn't had before, which is kind of a sin to me, but we're going into the sinful area. And with that, I would like now to introduce Uche. Uche, in addition to being a good friend and my former senior ICSID counsel, he is a consulting attorney in the international arbitration and dispute resolution practice here at ArentFox. His current practice focuses on international investment arbitration, commercial disputes, and advisory services. He has served as presiding sole and co-arbitrator in disputes before ICSID, the International Chamber of Commerce in Paris, the Permanent Court of Arbitration in The Hague, the Court of Arbitration for Sports in Lausanne, the American Arbitration Associations, New York, and the Dubai International Arbitration Center. He advises the state of Kuwait on multi-billion-dollar national focal point for environmental projects. As member of the board of the Silicon Valley Arbitration and Mediation Center, he is also on the panel of arbitrators of various arbitration institutions around the world. So ICSID, please take it away on this very interesting and I would say not so novel topic.
Well, thank you, Jose Antonio. You promised you'll keep it short, but you didn't. But the good thing is that you've kind of cleared some of what I was going to say. But anyway, welcome to ArentFox Schiff, and welcome to this panel on space law in the new space age. For our purpose today, space law, by space law, we are referring to the international and domestic legal framework governing activities related to the outer space. Now, among the early instruments in this regard is the Outer Space Treaty, which came into force in 1967. And that was just 2 years after Lloyd's of London had issued the first space insurance policy, so all somewhat recently. This OST was followed by some other treaties around the same time, and later by national and regional legislative initiatives. It's fair to say that the early treaties came about in a landscape dominated by national space agencies. Fast forward to the era we're in now, in which there are many more national space programs, and even more striking, many commercial entities are now involved in space activities. As of 2022, the space economy was said to be worth about $500 billion US. 75% of that was revenue generated by the satellite industry. Yet the sector continues to evolve. Today, there is talk about mining in space to recover resources from the moon and possibly later from asteroids to meet demands here on Earth. Now, although we're not quite there yet, the value of those resources is said to be in the trillions, if not quadrillions of US dollars. There's even talk of establishment of colonies in space. As you can imagine, there are many ways disputes can arise between the different players in the space sector. And ultimately, the question is whether arbitration is the best way to resolve such disputes. We have a formidable team on the panel to discuss the issues today. Profiles are all in the event material, so I'll only touch on them briefly. First is Pamela Meredith, who's chair of the Space Law Practice Group at KMS Zuckerberg here in Washington, D.C. For more than 20 years, Pamela has taught satellite communications and space law as an adjunct at American University's Law School here in D.C. Next, Pamela is Petr Polasek. Petr is a partner at White & Case, also here in D.C. Petr's main focus is on international dispute resolution and the protection of foreign investments, in particular in mining. Petr has also been involved in this new area of space resources, and like Pamela, in space-related dispute resolution. Now, I should add that the idea for this panel came from Petr, and we can't thank him enough for that. Next is Vivasvat Dadwal. who is a member of the international arbitration practice at King and Spalding. Viva is based in New York, between New York and Montreal. Viva is also a space law expert who, among many achievements in the area, co-authored a very detailed 2020 study on arbitration of space-related disputes. Finally, we have Scot. Those of you who were here in the panel earlier would have heard the introduction of Scot, but as far as this panel is concerned, Scot, who's a partner at Womble Bond Dickinson in Denver, describes himself as a mining guy. Like Petr, he has also more recently been focusing on issues around space mining as well as space colonies, and he has published on both subjects. So that's our panel. Turning to the issues at hand, to kind of give us a sense of where things are, I think we'll start with Pamela to say, can you give us an idea of what the space industry entails today, and what legal framework is there to guide them?
So you're asking for the whole lay of the land, right? Okay, I'll try to be quick then.
And I'll come to you, Viva, after that.
Okay, so talking about the commercial space industry, this satellite communications is by far the largest sector in terms of space activity, space assets, and revenues. Distant second and thirds are space transportation, which primarily means launches into space, and remote sensing or imaging. There are emerging areas, commercial space areas, such as space tourism, satellite servicing, and that type of thing. Those are few missions and far between, and generate relatively little revenue compared to these other sectors. So those are, in a nutshell, the space activities. I could talk about missions to the moon, but I think we have more enthusiastic panelists wanting to talk about that, so I'm not going to say anything. So now, in terms of the law, we have 5 space treaties, UN space treaties: Outer Space Treaty, Liability Convention, Rescue and Return Agreement, and the Registration Convention, and finally the Moon Treaty, which the US and most spacefaring, or I think no major spacefaring nation is a party to that. So for all practical purposes, 4 UN space treaties. All of those were adopted before 1980, and there's very little appetite for additional treaties with sweeping provisions like those types of treaties. Reason for that is the stakes are too high now. Too much is going on in space in terms of commercial activity and military interest in the space domain. So those are the UN treaties. Then we have the ITU, International Telecommunication Union. There are 3 treaties that primarily deal with spectrum resources. Frequency, access to frequencies is absolutely critical for all space missions. They have to communicate in some way with Earth, if nothing else for the TT&C, telemetry and command, tracking, telemetry, and command. So ITU, International Telecommunication Treaties, those are them. And then finally, we have domestic law, US domestic law, 3 licensing regimes: Communications Act of 1934 for all space communications administered by the FCC, Commercial Space Launch Act of 1984, administered by the FAA Space Office, and finally the Land Remote Sensing Policy Act, administered by the Department of Commerce for remote sensing. So Commercial Space Launch Act is the name suggests, launches into space. Did I do that fast?
Yes, you did.
Good.
And I'll talk to Viva.
Yeah, and I would add to that, I think Pam is right. You've got so space law is international law, and then there's domestic space law, and you heard from Pam about the U.S. domestic space law and the 3 acts, there are countries that don't yet have those types of laws domestically. Of course, you sign the treaties and then you bring those treaties back home and, you try to implement them. One kind of important point is also the rise of non-binding forms of governance in space in particular, because the 4 treaties, and I think you're right to point out the Moon Agreement has been demoted. In fact, Saudi Arabia recently, actually, there were 5 signatories, and Saudi Arabia actually pulled out of it. And I think Australia is party both to the Moon Agreement and something called the Artemis Accords. So I was talking about non-binding instruments. There's a rise of that. Instead of going with the UN multilateral world, more and more countries are using kind of guidelines, or one example of that being the Artemis Accords, for which there are 56 or so signatories around the world, which is far more than, let's say, the Moon Agreement, right? So there's been a rise of non-binding, non-legally binding instruments as well to govern space. As I mentioned, in terms of domestic legislation, I'm going to do a plug. There's something called Astro Portal, which is by the UN. The UN has gone out and mapped out every domestic legislation out there. It's called the Astro Portal. So if you go on there, you can kind of look at every country and what domestic laws they have to govern space. I think this is an important question. You'll see the differences between countries where there is legislation and countries for which there is no legislation, and for good reason. They might not have any space activities to begin with, right? So that's just, the UN has been doing a lot of work trying to build capacity, but in terms of the landscape itself, we've got the international law, which has the treaties. Of course, there's the UN. You've got non-legally binding instruments, including the Artemis Accords. We could talk a little bit more about that, I think, when we talk about mining, for which there are a lot more signatories than, for example, the Moon Agreement. And then you've got your domestic laws, which manifest in each country, the US being a big one. But of course, Europe has recently had a new Space Act that was been proposed. So keep an eye out for that one. It's going to be interesting how the two, Pam, I would welcome your thoughts on that, how the US laws and how the EU laws will align or not. And then, of course, all the new countries that will implement some of these laws because they want to be spacefaring. And I think that's really exciting as well. So I think that's the general landscape on space.
Well, thanks, Viva. Now that's half of the story, because there's this whole new area, space mining, space tourism, and so on. Scott, do you want to help us with that? And I'll be coming to you next, Peter.
Sure. So there are no active disputes in space mining at the moment because there's a little bit of kicking around, but that's about it. However, there are a lot of companies spending a lot of money trying to position themselves to develop resources in outer space. And as a result, trying to develop a legal framework that provides the commercial certainty you need as things go forward, especially with the potential for disputes in this area, is something that's getting some attention. So a bit tying into the kind of the treaty framework we've talked about, the Outer Space Treaty doesn't really mention space mining or resource development explicitly. It does talk about the exploration and use of outer space. And so that and use, those of us who are interested in mining in outer space, we put a lot of weight on those two words in addition to just the exploration. But there's other issues. There's the non-appropriation doctrine, right? You can't go plant a flag on the moon and say we own the moon, plant a flag on an asteroid, say we own the asteroid. So there's interesting questions common when you talk about mining that, the minerals in the ground are owned by the government. Once you sever them, they become personal property. They owned by the mining company. They can go sell them. Whether that concept carries over into outer space. And the kind of received wisdom is it does, but there's also folks who don't think that's how it works. So that's an area where there could be some tension going forward and trying to stabilize that. There have been some attempts in addition to the Artemis Accords, which clearly provides a framework for the signatory countries to develop resources on the moon. And just to tick and tie that a little bit, one of the things that the Artemis Accords does, it includes the concept of a safety zone, which is fairly amorphous at the moment, but allows The idea that I say, I'm going to go conduct an activity on the moon, I'm going to describe this zone where I'm going to be working, I get some level of exclusivity there and have the ability to have other people not do what I'm doing there. Interesting part is that neither Russia nor China or a lot of other countries, 56 out of however many, 152, depending how you count, there's some who haven't, may not agree. And China and Russia have been very vocal that they don't like the Artemis Accords. They think their imperialism run amok, not so keen. But they also have their own plan to develop a lunar habitation, the International Lunar Research Station, some in orbit, but some activities on the moon. One of the things that makes the moon compelling is that there's ice. Now, there's not ice like ice cubes, but there's water embedded in rock, in pore space in rocks and on the poles. And you can go into the rock, mine the rock out. Colorado School of Mines, you can get a PhD in space mining engineering there if you would like. And they're actually developing technologies to volatilize the water out of there. Nice thing about water, you get oxygen. You get hydrogen, which is fuel. You get water, pretty handy if you're going to be living on the moon. So that's a high area of interest. The International Lunar Research Station is going to be in the southern polar region, just happens to be where the ice is. So there could be some competition for a resource among countries at that point. And the other thing is on this issue of interpretation, the United States and Luxembourg have kind of led the way in passing statutes. The United States Commercial Space Launch Competitive Act has a Title IV Space Resource Exploration and Utilization Act, and basically interprets the Outer Space Treaty in a manner that says, yes, you can go to the moon and develop resources, you can keep the resource and use it. Luxembourg has a similar statute passed in 2017 that has the same interpretation of the Outer Space Treaty. To take advantage of that, you just got to incorporate in Luxembourg. And Luxembourg wants to be the Delaware of space mining, basically, and they position themselves for that opportunity. So that's kind of the framework we're working within. The only other thing I want to at least make a passing mention of asteroids. Moon's where the activity is going to be in the near term, right? There's a lot of focus and a lot of attention there. And again, where there could be some competition and potential disputes. But there are companies looking at mining asteroids, and just to get a little, it'll be down the road a bit. There's some work. It takes 2 years to get to them anyway, so it takes a while. But there is a website called AsteRank that has the economic value of asteroids ranked. So you can go through, find your favorite asteroid, and figure out what it's worth. The nice thing about AsteRank is it tells you the value of the asteroid and how much it's going to cost you to actually monetize it. My favorite asteroid is Ryugu, which the value of Ryugu, and there's a mission that went out there that actually landed on it, brought some samples back, so I have a pretty good sense of what's going on. But there's some organic stuff kicking around there too, which is sort of interesting. But value of Ryugu, $82 billion. Your net profit, $30 billion. So even though it's going to cost you a lot to go get it, $30 billion in your pocket, not bad. There's another one, UW-158. The press says it has trillions of dollars of platinum in it. It's a near-Earth asteroid, so you just grab it while it's going by. AsteRank has it a lot lower. What is it? $6.69 billion, so a lot less than a trillion. So there's some discrepancy about the value of UW-158, but do your due diligence before you invest in that one, I guess. But again, as attention is being paid to this and people are investing money and starting to go out there, there's these tension points, both in just how to interpret the fundamental structure we're working in. And I agree, there's not going to be a new outer space treaty anytime soon, right? So this is the structure we've got, which is like a constitution, very high level structurally. How do you navigate that? Where are tension points? And then this potential side-by-side activity. The moon's a small place, and where you look for the resources you want, even a smaller area to operate in. So the chance of some friction arising there is possible. I was going to say likely, maybe not likely, but at least possible.
Thanks, Scott. Petr, you want to add to that?
Okay, thank you, Ucheora. So just a point concerning the treaty framework. So the 5 space treaties date back to the 1960s, as we've heard, and they are basically the product of the Cold War. So today we are in a new era. It's basically an era of competition between the United States on the one hand, and China with what is now its minor partner Russia on the other hand. And so it's really a new space race, basically. And that is accompanied by a really unprecedented involvement of the private commercial sector across the board in basically all the space activities. So there is really a fundamental question whether these treaties will support the development of space activities going forward. Among other things, they do not contain a binding dispute resolution mechanism. There is a commission process for things such as resolving questions of liability for damage caused by space objects, but the outcome of that process is not binding unless both parties specifically agree to it. So we do not have, at the international law treaty level, we do not have a binding mechanism for such disputes, whether state to state or private to state or anything else. And so what we are seeing is, I think, like a new competition among individual countries trying to establish themselves as a place for or domicile for space activities. I just wanted to add to the point concerning the United States. There has been one thing that has been consistent across the U.S. administrations is the support for private sector activities relating to outer space. So the first Trump administration, the Biden administration, the second Trump administration have consistently supported a private enterprise in space. And so maybe the latest example, President Trump issued on August 13th of this year an executive order which is titled Enabling Competition in the Commercial Space Industry. And what it seeks to do essentially is to cut the red tape on permitting and licensing to boost the US commercial space sector. How that will be implemented, we will see. But that is, I would say, in competition to jurisdictions like Luxembourg, which are also seeking to attract space investments. And maybe another point, just as an example of like the new and emerging space industries. One, and this is again a US focused example. So payload delivery services to the moon. This is a program that is run by NASA, and its objective is to hire private companies to deliver payload to the moon for NASA. And the way they do it, it's competitive. So the way they do it is they conclude contract with companies that have this capability or that are developing this capability to deliver payload to the moon. And then once these contracts are in place, those companies can bid for individual orders. And so among those orders, in March of this year, a company called Firefly Aerospace successfully landed a lander on the moon, which carried 10 instruments for NASA. And that was part of this program. Further missions are planned for 2026, 2028, 2029. Other companies like Blue Origin, Intuitive Machines also have contracts as part of this program with NASA. And those contracts are worth, at this point, hundreds of millions of dollars. So that's just an example of something that didn't really exist not too long ago. And now this is a whole new competitive sector where you see private companies basically competing and delivering spacecraft to the moon.
Thanks, Peter. Before we leave that section, I'd like to hear from you and Scott in terms of where things are today. I know there's some discussion about the feasibility of all these, whether in the short term or the long term. You talked about delivering payloads to the moon. How close are we to the establishment of these colonies, and how close are we to the start of mining on asteroids? I don't know.
No, I'll go out. I'll hang out on a limb on this one. Part of it is, the Artemis program has been around for a while and sort of the funding gets hung up. The thing about the Artemis program is that it is one of the rare instances where it's been fairly stable across administrations, which is mind-boggling that there is such a thing in the world. So there's at least some impulse to pursue this. That said, it keeps getting delayed and there's funding issues and government shutdowns that might interfere, that sort of thing. So, the timing is an interesting question. I think I've been saying for 5 years, it'll be in the next 10 years. So I'm going to go with the next 10 years again, because it seems like the kind of time frame in which this could happen. The thing is, once you decide that you're going to go set up a base on the moon, whether it's the Sino-Soviet one, I'm going to go old school on that, whether it's the Russian and Chinese joint venture or a US or Artemis Accord base, the concept is always that it's going to be sustainable and self-sufficient. Now, it's not going to be entirely self-sufficient, but getting the moon ice and turning it into water is going to be a key part of that, of trying to avoid having to haul water to the moon. And if you can do it there, it's huge. The Chinese have come up with a process where you can make bricks out of the regolith. The regolith is just the dust that's laying on the surface of the moon. You basically cook it, sinter it, melt it, and you can take the regolith and turn it into building materials. There's iron and aluminum on the moon. The idea is you process it there, use 3D printing kind of technologies. The point is, once you set up shop, you're going to do as much as you can there as opposed to bringing things in from the Earth, because it's very expensive to do that. So if you can get basic building materials and water and fuel and oxygen there, that's a huge saving. So once we make the move, the resource development is going to start taking place. And then the question is just on timing. I don't know in the Chinese, Russian, how quickly that's going to move. That's a bit of a opaque to us. On the US side, there's, things just kind of keep getting delayed. But, once you're there, so I'm going to say 10 years. I think if we get folks on the moon and start building that, we'll start putting things into place. And again, like I said, people are already doing the engineering and the work to actually figure out how this will happen. So it's not starting from a cold start.
I just wanted to add just one kind of nuance, because I don't think we've talked about this one yet. You've got your satellites, right? And you've got your Earth, you've got your satellites, and there's different kind of levels at which these satellites exist. And those satellites will cost different. It'll take a long time to make them, et cetera, et cetera. You've got your satellites. You've got the moon, which is out here. We haven't talked about the stuff in the middle, really. And there's a lot happening on the space station front. So the International Space Station, which has been around for, I think, one of the greatest projects between countries, it will be retiring at some point, right? And at least that under the US policy, the idea is to replace it with private actors. And so there are private companies building their private space stations to be in outer space, to be property in outer space. They will carry the flag of the US, depending on, we can go into kind of launch state, et cetera, and who does it belong to specifically, which laws govern, et cetera. But I think there's that middle space as well, which I think probably we'll get to sooner, unless something goes wrong. Of course, if anything goes wrong with space, everything goes kaput. So that's, everything stops. But I think before the mining, my sense is, and I'm no technology, space engineer or anything like that, but I feel like there's a lot, I think we'll get to the space station sooner than we will to mining.
Well, thank you. That clearly sets the stage. Pamela, you've got an active space practice. What sort of disputes are we seeing today in this sector?
Well, we see, your typical contract disputes, private contract disputes that you have in all industries. For example, satellite companies and satellite manufacturers, or launch service providers, or insurers, lenders, suppliers, you name it, that sort of thing. Now, what's a little different in the space industry, I think, is if something, we're talking now about the commercial space industry and private contract disputes, is if something happens to the satellite, either on the launch site or during launch or in space, in those situations, you don't typically have the dispute with the satellite manufacturer or the launch service providers, as you might think, but instead, to the extent the satellite is insured, you would have that dispute, if any, or at least a claim against the insurer. So why is that? Well, the reason is the contracting practices in this industry. Just give you a snapshot, satellite manufacturers do not take responsibility for the satellites in space with respect to the customer. So if there's a defect or the satellite malfunctions completely, the manufacturer has disclaimed warranty. So then the satellite operator is exposed and will look to the satellite insurer to the extent they have a policy. Likewise, there are statutory requirements for waivers of liability in contracts with launch providers, so that you can't, as a satellite operator that's lost your satellite, you can't sue the launch provider. So you're exposed, again, to risk. So to the extent you're insured as a satellite operator, you will file a claim. And to the extent your policy qualifies for, or you qualify for coverage, the insurers will pay. And if not, well, then you have a potential dispute. So the question is then, how is that settled? And maybe that's your next question, is it? I'll leave that for, you can I'll leave you in suspense.
Yes, thanks. So Petr, in this environment, would you say the usual protections under investment and trade treaties for all these massive investments we see in the area?
Okay, so I'll focus on investment treaties.
Yeah.
And that's putting aside the commercial disputes. So you'll be kept in suspense for a little longer on that one. But when it comes to investment treaties, I think the distinguishing factor is whether the investment is made on Earth in a particular country, or whether it is located or made in space. So when it comes to space-related investment on Earth, those might be protected by investment treaties such as any other investment. So for example, if you have an investor from country A who makes an investment in country B relating to space, whether it's telecommunications, satellites, launch services, whatever, and there is an investment treaty between the two countries, and country B takes some action that damages the investment, then the investor might have an investment treaty claim against country B, just as if the investment related to any other industry. So that's not anything special there. I would say there are two examples well known of such investments. The first one involves two arbitrations against India. So these were brought by Deutsche Telekom, the German telecommunications company. That was one case under the Germany-India bilateral investment treaty. The other one was brought by a Mauritius incorporated special purpose company under the Mauritius India investment treaty, and they related to the same facts. Those were that the Mauritius company called Devas concluded an agreement with an Indian state-owned company called Antrix for the lease of capacity on 2 Indian satellites. And later on, the Indian government basically decided that that capacity would be set aside and reserved for government and other strategic purposes. And so Antrix, the Indian state-owned company, terminated the agreement, and that was the end of those investments. So those investors pursued investment treaty arbitration. They were successful. Deutsche Telekom won in 2017 a sizable award of damages. The other case had a bifurcated phase, so there was a jurisdiction and merits award in 2016, followed by a damages award in 2020. And these awards are now subject to enforcement in various courts. So that's one example. The other example relates to the investment of a French company in Mexico. This was Eutelsat, and it is a similar pattern. Basically, what happened there was that the investor had a Mexican project company or subsidiary which held a license for a part of the spectrum, and the Mexican government, basically the law and or the Mexican government required that a part of it be set aside for military and government purposes. And the complaint that the investor had was that the investor was required to set aside a larger section than its competitors. So this was, according to them, this was discrimination and other violations of the bilateral investment treaty that was in place between France and Mexico. That case was dismissed. So we will probably continue to see those types of cases. They relate to space, but they don't concern conduct that takes place in space or investments that are based in space. That's a completely separate area, and that's where we lack at this point the legal framework to provide remedies to investors and resolve those disputes. And the reason is because, as we heard, the Outer Space Treaty basically prohibits any country from asserting sovereignty over any part of the space or any celestial body. So that means that no state can claim any part of the outer space as its own sovereign territory, and that also means that you cannot extend your investment treaties to this to space because it's not yours to be regulated. So we do not have investment treaties or any other international law framework that would provide something like the possibility of bringing an investment claim. I would say, though, that there might be a way for investment treaties to come in play, and that is if, for example, if a country gives a license or a launch permit to an investor from another country with which the first country has an investment treaty in place, then one could say that the license itself is an investment, or that the launch permit is an investment. And then if the host state does something in space, in outer space, let's say that they conduct a completely reckless military test that destroys the investor's satellite by accident. So even though the harmful conduct occurred in space, because it impacted the value of the license, arguably, that might be a basis on which to bring an investment treaty case. So it is possible that we will see those cases coming up. This is not a hypothetical scenario because, as we know, Russia and China have been testing anti-satellite weapons, which caused issues in space, such as a debris field and other things. So these disputes might happen in the future. But again, we do not have the equivalent of investment treaties protections in space if this nexus is not there. So if you don't have an investment in another country, which the other country impacts by its conduct in space, you do not get any protections. You could, in theory, have your own home state espouse your claim and pursue a claim under the liability convention, maybe. But if the other state does not agree for that process to be binding, you will not get anywhere.
Thanks, Peter. Viva, you did this fantastic study, which you keep reminding me has been a few years, but
It's really old.
But I think there's something to be learned from that. Can you just tell us a little bit more about what you discovered when you were looking at these cases? You know, what sort of issues were coming up before Pamela tell us about the
The
commercial.
suspense. Yeah, we're still hanging in suspense. Pamela, we're going to come back to that. No, I mean, I think everything that's been said is what this was, I think, 2020. You know, I wanted to see what was out there in terms of, you know, is arbitration being used? Of course, it's different than litigation. You can't, you know, you kind of have to go searching for, you know, any mention of an arbitration involving satellite space, et cetera. So went through and did that exercise. Everything that's been said already is kind of what the study found, really. I think there were, at the time, I think Davis had been filed and you know, Eutelsat, Mexico. There's a couple of other ones that were around, but it was primarily commercial disputes. Basic ICC, you know, basic contract. You know, the only thing that makes it space is the fact that there was a space component, let's say, right? You know, the sector is a big one, and I think you'll find that there's gaps in kind of, again, when I did this is Earth and this is where the satellites are. Our disputes are basically within this. There will be disputes with respect to satellites, very few. I mean, it could be the ones that Pam mentioned. There's disputes on Earth about space things that, you know, your GPS or your data that you've purchased, et cetera, but it's just like a contract dispute. Everything above that area, we really don't see the disputes show up. And I mean, part of the question, and this is kind of confirmed in the research, is, you know, who is the dispute between? Who's suing who and for what? And there's such few, just no one is in space. I mean, there are people, again, in that very busy satellite area, but beyond that, there's not much happening. And so that's something that the, you know, study confirmed. You know, I'm excited about kind of, Peter, you've talked about what will happen to the stuff up here where the dispute's happening in some bad act, so to speak, happens in outer space. And then you're a private actor. What are you going to do? I think that will be very interesting to see, particularly because we haven't talked about this, but, and this is something I did not focus on in my study, but the dual use, you know, space objects, which basically just means, you know, satellite or any space object really having a dual purpose. One is military, the other one is civilian. I think that will be very interesting to see. And we've seen it play out in recent wars already, where private actors are investing a lot of money to put a lot of things in outer space, and those services are being purchased by countries, for example, for things that countries do usually and private actors don't do. And will there be disputes from that? I think that will be very interesting. And the other thing I would just flag, which we did not find in this old research, was state-to-state disputes. Because we've talked about two private actors, we've talked about, you know, a government and a private actor, and then of course there's the state-to-state component, which I frankly hope there would be a state-to-state dispute sometime soon, just to kind of see where things are. But the only example we have is from very many decades ago, and when it comes to things like cybersecurity, when it comes to things like environmental degradation, when it comes to, again, things like satellite jamming, which kind of often involves some sort of nefarious kind of military type, you know, activity. When will we see disputes around that, or will we see disputes around that? And then will they ever be made public is a separate question. So that's kind of the overview of the study, generally confirming what Pamela said about their commercial plain vanilla involve a, you know, space component, but really just could be a contract dispute. Seeing some elements of what Peter talked about in terms of investor state, but really not kind of matured yet, partly because I think the market is not really ready. I mean, there's a lot of money being put in, and a lot of the governments buy your services. And so do you really want to sue a government necessarily? So, and then, yeah, like I said, the state-to-state angle, which we'll see how that unfolds. I think it will unfold, but we'll see how it goes.
Thanks, Viva. Sounds like we're demystifying the whole thing into commercial disputes. So how have these, from your practice, Pamela, how are these being resolved? There's been talk about arbitration, possibly litigation. What exactly is going on? How are they being resolved to these disputes?
Well, yeah, I'm sorry to bring it all down to earth, but it really is there where the action is. So, not to deflate you all, but It is exciting though, because you are dealing with very complex disputes involving spacecraft. You know, insurance disputes, as I said, it often ends up there as an insurance dispute when you have something happening to the satellite. Typically, insurance policies have arbitration clauses. It's pervasive in the industry. Also, to some extent, in with satellite manufacturers, not so much for launch companies, but it is well suited for the space disputes, because you want confidentiality that you have in the arbitrations. You want some means of protecting your materials, because it's usually export controlled. So you need, before you even get started in the arbitration, you need your necessary licenses, or TAAs as they're called, whatever it is, whatever regime, export control regime you're under. So that's all very important. Now, when it comes to the rules, you know, it comes to the general ICC and LCIA or other the American Arbitration Association rules. We apply those same rules to space disputes. I know there are specialized rules that have been developed for space disputes, but they, in my experience, they really aren't used. Again, it boils down to the mundane and usual. But still, it is exciting. I don't want to take that away from you. Now, you talk about state-to-state disputes. There have been disputes of a radio spectrum between states. There are, you know, Iran and I think France supporting Eutelsat over jamming of signals. That dispute could have been resolved through the ITU, International Telecommunications regime. They have arbitration clause in that regime, not much used. Article 41 of the ITU convention. And the radio regulations, Article 15, if you want sites for these kinds of dispute resolutions. There is an arbitration clause in the International Space Station Agreement. Again, I'm not aware that it's ever been used. There aren't that many disputes between states in space that I'm aware of, and maybe that's just good, right? I know, you know, our disputes are good for lawyers, but for humanity, the movie may be better off without them. So I could go on, but I'll let others.
Thank you, Pamela. It sounds like these disputes are being resolved using the traditional means. And so the question is, are those sufficient? Do we need something new? The PCA has a set of rules, which, as you mentioned, they don't seem to have been used. There's even a list of arbitrators, which I'm not sure what's going on with that, and list of experts as well. So I'd like you each to tell us if you think that there should be a separate mechanism, a specialized mechanism for the resolution of space-related disputes. Before we get to that, though, I'd like to turn back to Scot. Looking at these new areas, the disputes are not there yet, but are there any types of disputes you anticipate to be coming out as we head into space mining and space colonies and so on?
Yeah, there are threads. There are open issues that need to be resolved, and as long as there's ambiguity, once the money starts flowing, there will be disputes because people think they should have more money than the other people have or they're getting. So that will heighten this opportunity. And there's some areas of uncertainty that I think will have to get resolved as part of that process. One of them is whether the company that's generating resources on the moon or from an asteroid has to pay a royalty. Under the law of the sea, because the sea is the common heritage of mankind, that's the phrase that's used, the International Seabed Authority eventually someday we'll get around to creating a royalty. They should have done it by now. They actually, anyway, that's a whole mess we can talk about separately. But there's supposed to be a royalty already kind of sorted out if for development of mineral resources from the sea, and it goes paid to International Seabed Authority. And the idea is that it's to benefit developing economies, people who don't have the ability to go mining under the ocean and share. Not at all certain whether that applies in outer space. The Moon Agreement has the Common Heritage of Mankind language in it, and there's an argument that the Moon Agreement was designed in part to make sure you tag into what the International Seabed Authority is doing to get a royalty generated. However, the language in the Outer Space Treaty, not the same. Exploration, I'll get it right here. Exploration and use outer space should be carried out for the benefit and in the interest of all countries. So not quite the same thing. And so there's this open question about whether you're going to do something like what you do in the deep sea and have some kind of revenue sharing mechanism. It's just an open issue. Arguments go both ways on that. It's unresolved. The problem is when you're doing your economics and whether you're going to go make an investment to start generating helium-3 on the moon and bring it back to Earth and sell it, do I pay a royalty or not? That's matters. And if I do, what's the number? And so that's an issue where there's going to have to be it'll be posed at some point eventually. The other area where I think there's going to be interesting developments are rogue actors, we'll call them, Elon Musk. So Elon Musk wants to go get a colony on Mars. And if the dispute resolution provision in your Starlink contract says California law, however, if you're doing activities on Mars, then it's subject to Martian law, which has nothing at all to do with terrestrial laws, entirely separate. And kind of inconsistent with the Outer Space Treaty, pretty much everything we've been talking about. But when you're on Mars and you set up shop and somebody brings a claim there, how are you going to resolve that? If that gets any legs, I mean, it's kind of cute right now, right? But as things develop there, that's something that's going to have to be resolved. And then there's just the nuts and bolts activity of, if you signed on to Artemis Accords, it's a contract among countries, and you set up a safety zone and one of your co-signatories of the Artemis Accords doesn't honor your safety zone, there's a claim. Or if you do safety zones under Artemis Accords and somebody who's not a signatory comes in and jumps your claim, how do you resolve that? These are the kinds of things that are going to have to get sorted out. And again, speculative at this point, but as money starts moving that way to make investments, getting some answers to those questions are going to be important to say, yes, we know exactly how this is going to work out, and here's the pathway going forward.
Thank you. Pamela, you wanted to say something, and we'll open it up to the rest and then questions.
I want to make a quick comment on that reference to Elon Musk as rogue actor. I can tell you that Elon Musk has singularly changed the paradigm for space. We are where we are today only because of Elon Musk. We would be going to the space station on Russian rockets if it weren't for Elon Musk. We would be launching satellites on European launch vehicles at 4 times the price if it hadn't been for Elon Musk. We wouldn't have anywhere near the space economy we had to have today without Elon Musk. And I can say that with 40 years of experience in this industry doing only satellite and space law generally. And I would say Elon Musk has done a phenomenal service to the space industry and humanity at large.
Thank you. So next, the next phase is to see what we consider would be the ideal world. If what we have now, are they adequate? If not, how do you design the ideal dispute settlement mechanism for space-related disputes, both for the present and the future? You did mention that there were some, Pamela, you mentioned that there were some peculiar aspects of dispute resolution now through arbitration, perhaps with discovery and so on. Is that what do you have to say?
Yeah, I mean, I could say that there are, there are difficulties that arise in the discovery process for satellite arbitrations because of the export control and proprietary nature of the materials. And in an insurance dispute, you typically have the manufacturer with all the important information that you really want to get your hands on. So you want third-party discovery, which is not always easy to get in an arbitration setting. So then you have to get it out of the satellite operator that is the, if you're representing an insurer, which I've done mostly. So that can be difficult. So that I'd say is a peculiar aspect of the arbitration. I'd say also that all of the arbitrations I've been involved with have been confidential. Nowhere near are there any traces of these arbitrations as far as the parties can help it, because it's a small community and very often the parties have contracts with each other. We could have disputes where there are, insurance policies in place between the parties, or a dispute with a manufacturer where you have a second satellite on order. So you want the confidentiality and the little more, at least in theory, collaborative environment of the arbitration. So I could go on, but I'll.
Then we'll work our way down. So Petr?
Okay, so when it comes to commercial disputes, the type of dispute that Pamela described. So, what we have at this point seems to be working adequately. So that's the usual dispute resolution fora, the usual arbitration rules that we see in other types of cases. That's what is being used in those cases, as far as I could see. And I really haven't seen the industry calling for anything else. So it, I think, is a testament to the flexibility that these traditional fora and rules provide. They work just fine for space-related disputes as well. There have been efforts to create new rules specifically for space, but they haven't been used, again, I think, because they are really, at least at this point, they are not needed. So we will see in the future whether that changes as the industry continues to expand. But as of now, I don't think there's a need for it. I would say, with respect to the treaty framework, the international level, state-to-state level, we will never get, at least in our lifetime, to the ideal world. I think that's not happening. There is not going to be another treaty like the Outer Space Treaty. It's not realistic. So what might come next instead is the development of, maybe let's call it like regional legal frameworks. So under the umbrella of the Artemis Accords, which actually already provide expressly for the future development of further rules, we might see new rules coming out of that. And so the United States, the 56 countries that are parties of the Artemis Accords, Senegal, the latest in October, so they might develop something that will govern that half of the world, including possibly eventually dispute resolution mechanisms that will be binding, that will apply to investments. We shall see. But that will be one area. Then on the other side, you will have countries that are not aligned with the US interests, Russia, China, others, countries that are not prepared to take a stance. And those two things will not interconnect. So then the question comes, what will be the legal regime applicable to situation where you have a problem occurring between those two camps? And there one possibility would be like the emergence of unilateral legal regimes in individual countries, so that, for example, the United States might make the decision to enact domestic legislation that would impose sanctions on any country that causes damage to US space assets, whether these are state-owned, publicly owned commercial assets. If that sort of thing happens, it would give the president the authority to sanction the other country or its businesses. So that's it's kind of like looking into the crystal ball, but that's what I would say if I were asked to do that. Yeah.
Thanks. We'll be coming to the audience very, very soon. Scott, do you have anything to add, or should we go straight to Viva? Straight to Viva. Viva.
Yeah, no, I think to answer your question, is everything working? Do we need anything in the future? Yeah, I think everything is working. I think it'll be, I hope that any dispute, firstly, I agree with Pamela. I really do hope that there are no disputes between states that end up being resolved in a non-peaceful way. So that's, I think, very, very important. And I again, we haven't talked about the military aspects of space, but I think that's a very important field. And that will continue to be that way. And I think that's just, as long as we live in a world where there are states, that's how things are. And I think that's how they will be. And so I do hope that, in terms of the commercial angle, I think that, we need to just continue. In terms of the disputes that we see in the future, including any kind of military ones, I hope that, things are resolved peacefully. And, I think we talked about Artemis Accords. The development of customary national law, I think is to me, I think that's where the most movement will happen. Even with the Artemis Accords, you have 56 countries that are agreeing that resources are property, right? And space resources are property, which is more than Moon Agreement, which, did say the similar thing. And actually, I think if I remember correctly, it does talk about access and benefit sharing in some way, but countries are actively signing away from that, right? Like Saudi Arabia, like I mentioned, withdrew from the Moon Agreement. So what do we expect from countries specifically, as these industries grow? I think will be really interesting. And hopefully, again, it's done in a way that's peaceful. I think that's all I have.
Thank you. And I think it was Karl-Heinz Bockstiegel that mentioned somewhere that there really should be no need to establish something special.
We do not need more. We do not need more institutions. We do not need more rules. I think we've got it covered.
Right. I think we're in agreement on that. So I think that's the whole thing in broadly speaking. Of course, there are areas that we haven't touched on, and would like to see if there are any questions to start filling these gaps. So maybe, okay, we'll walk our way from front to the back. Alex? And then next.
Thanks, that was a terrific presentation. Alex DeGramont from Womble Dickinson. A comment, and what I think is a question. Comment is, I don't think I'm ever going to be involved in a moon arbitration, but I look around the room and I bet there are a lot of people who will be, right? Which is kind of exciting. The comment, and I don't want to get into the Elon Musk debate, but I mean, there are people who have contributed enormously to technology who nonetheless have sharp elbows and are territorial. And if you look at, well, I mean, frankly, if you look at what's happening today in the world, if you look at the history of humanity, it's very hard for me to imagine anyone spending lots of money to establish, say, a colony on the moon and not claiming some degree of sovereignty or ownership. And I wonder how those, if we believe that those treaties are going to be honored.
I think Pamela is itching to take that one.
Well, yeah, I do actually, because it's a very good question. And I think these treaties will be around, especially the Outer Space Treaty with its regime, only as long as it serves the interests of the mightiest nation on Earth. The day we find it in our power to go there and stay there and defend wherever we're going in space, I think that treaty will be history. We will withdraw from it, and we will do what we need to do to further humanity's quest of exploring space. I think the development of airspace is a good history lesson on that. What happened after First World War, where we understood, or where countries understood how important airspace was. Sovereignty You know, that became the big thing. And then, of course, that was codified in the ICAO, the Chicago Convention. So I'm stopping right there, but I think it'll be around as long as that. Good question.
Could I add some? I mean, I think in some ways it's also a question about state and non-state actors. And, you know, we've talked about Elon Musk, and I agree with you. I don't think we would be where we are without him. You know, so I think what's the role of private actors going forward? International space law and even domestic space law, right? We all need states, and it's all based on a state-based system, right? And so it doesn't really apply to private actors as long as states, you know, if states enforce the law, then it applies to private actors. If states are not enforcing it the same way, then it doesn't. And so, you know, does the Outer Space Treaty apply to a moon base that is a private moon base? Who's going to go enforce it, right? I mean, if let's say, you know, and I do hope, personally, I do hope that we get to Mars or even the moon, or even just more simply just a private international space station. How will that be governed? I think will demonstrate what happens in the future with respect to the Outer Space Treaty and the future of that treaty.
Thank you. Maria is making, yeah, but we've got two people, right? Yeah, okay.
Thank you. I always think the space panel is the most interesting one of the week for sure. The question is not necessarily for Scott, but I know you mentioned the Artemis safety zones. And I was wondering if you think they function more like the narrow temporary safety zones around offshore platforms, or if you see them more as like going towards EEC style exclusivity. And then depending on that, then like what practical safeties could be implemented in contracts to make sure that they are compliant with the Outer Space Treaty.
Yeah, I envision these, and it's only a vision at this point, right? Because it's still very loose. But my expectation is people, I mean, the thing about the ice mining is fairly localized. You know, I mean, but if you start actually manufacturing things on the moon and getting resources to do that or making bricks, I see the safety zone construct is the best thing we have in place right now to be more permanent, right? Where you'd have some exclusive right to develop and sort of be able to make the investment, even if it's a governmental investment, to develop that. But I think that's going to evolve. The other thing, picking up Viva's point about customary international law, I mean, the way mining worked historically on Earth is that people go start mining, and then they develop customs about how they're going to, you know, avoid these conflicts among themselves. And I think that's a good analogy of what's likely to happen here, where you set the safety zones up, you start operating in them, then become sort of ossified over time, and people honor the custom. And the question is whether people honor the custom or not is going to be where the tension starts arising and whether they become enforceable. But I see them as more stable than just temporary, because you're going to have to make a longer term investment to really make these things happen.
Thanks. Last question.
Good evening, everyone.
Okay.
It can be from Stephen Woye. I'm into private practice. My question stems from the recent initiative by the European Union. Precisely in June 2025, June 25th, 2025, the EU released a draft Space Law Act. I'm very sure the Europeans are very familiar with this. That law seeks to more or less promote safety, resilience, and sustainability of infrastructure projects, and also the regulation of private players in space exploration. I carefully looked through that law because I was trying to put up a proposal, a research proposal. There was no mechanism for dispute resolution, and I researched further on it. Apparently, what they did with that law, or this proposed draft, which is still before the European Parliament, is that they used established enforcement mechanism and dispute resolution mechanism for that same act, for the same draft law. Now, the question is the EU taking a lean-back approach that we're not going to get into arbitration? We're just going to do what we have already in terms of going to the European courts to enforce this law? There are provisions that says that regulators can go upon premises to inspect space infrastructure to ensure that they're in full compliance. And it simply says that it seeks to achieve harmonization of space exploration and space activities in the European Union. Now, this is a draft bill that came out just a couple of months ago with no provision on arbitration, rather than referring it to the regulators and the state court. So the question now is, what's the panel's take on this? Is there a need to make some intervention to say, why not arbitration? Because in that same law, private parties will be regulated, non-EU parties and private parties will be regulated by this act, and they will still be referred to staff that are required to register in the EU and have presence in the EU for them to do any activity with an European party. So it's something that is worth looking at. The draft's about a 150-page document. It's available online. You can carefully look through this draft and see what it provides in terms of regulation and dispute resolution. Thank you.
Okay. When it comes to the EU, I always think that less is better in terms of regulation. So if they didn't wade into that territory, it's probably for the better. So that's my comment.
I would just add, I mean, I think it's more from what I understand, and look, I haven't read all 150 pages, but it is more of a governance type of act, right? And so similar to, let's imagine any country, I know it's EU, which is supranational, but if you have an act generally, and a country passes an act, I wouldn't really naturally think that should be disputes coming out of that act should be going to arbitration. Often, you'll think about administrative courts, you'll think about courts in general. So to me, it's not as surprising that the EU Space Act, the draft form, doesn't have arbitration. I wouldn't expect to see that in kind of a space governance mechanism. Now, if it's private or, if you've got a government tender, things like that, you would expect to see that, because then it's a bit different. But you're right. I mean, countries can have a standing offer to arbitrate if they want to do that. Maybe, Petr, there's some, we were talking about future kind of mechanisms that might come up where there's a standing offer to arbitrate in a legislation, but not in my experience, at least. I think I've only seen that go to courts domestically, because that's where we are. So it's not as surprising to me.
Thank you. We'll just go to the very last question, and then we head to the reception.
So I want to say thank you to everyone for such a fantastic panel. My name's Tom Villalon. I'm at 3 Crowns. I do international arbitration, and I'm a self-diagnosed mining nerd. And my interest is both mining on land, submarine, and now apparently space mining. But I wanted to, this is less of a question, more just sort of a comment of perhaps on an optimistic note. We talked about, my colleague Alex here said that, moon arbitrations may be a while out, but asteroid mining is pretty fascinating. There's 2 companies I've been following, both, of course, in California, Astroforge and TransAstra. And Astroforge just finished, I think they're like a 55 million Series A round, and they're launching their, I think, 3rd out of 4 missions next year to actually land on a M-type asteroid, near Earth orbit asteroid, and do different measurements and refining. And then their next program is supposed to be probably 2 years out. It's actually going to retrieve, hopefully, some PNG and bring them back to the terrestrial realm, where we meager earthly lawyers hopefully will get to engage in disputes. So I just wanted to throw that out there to just, as a point to say that perhaps the private sector will ramp up not just innovation, but also the speed of exploration, refining, and then return of these materials to Earth.
On that positive note, yes, there has been a trip to the moon, and look, lunar rock has been brought back, and so that is like, yeah, I agree. And there was no ICJ case. There was nothing really happened. Rock was brought back to Earth. It's stored in, right? Like, so there are kind of positive things to look forward to. Sorry.
Yeah. Well, just to round that off. So one of the guys who collected the rock is a guy named Harrison Schmidt, who was on the Apollo 17 mission, a geologist, Harvard-trained geologist who went to the moon to look for rocks. He's involved in a company called Interloon that's looking to develop helium-3 on the moon and bring it back to Earth for fusion fuel. So yeah, speculative, but they actually are on a mission right now to do their first sort of volatilization. So it's all full circle, right? Like, the Apollo astronauts brought rocks back and nobody complained. So arguably we've got a precedent, maybe not the greatest precedent, but it's starting to build on that, and people are taking this seriously, and there's money going to it. So,
yeah, and to your point, so Astroforge had 2 failed launches. Hopefully the next one will work out. But Karman Plus, which is the other one, they just raised $20 million this year. So there is a lot of like serious money starts to go in, as Scott mentioned. And so, yes, this is an example of where the future is headed. Yeah.
So on that positive note, we'll call it a day. Please join me in thanking our fantastic panel, and we'll wrap it up here and hand over to the next panel. Thank you.